and you are live.
Welcome back to part 4 of the Commercial Division Advisory Council Summer Lunch and Learn series. We're here for the final program, which is going to be a spectacular program on trials, with my colleague, Robert Reed, Loretta Lynch, our former Attorney General of the United States, and her partner, Dan Toal, who's coming back a second time to join us. Thank you so much to all of you for joining us. And before I turn it over to you, I just want to remind the students and associates to go to the court's website if you're interested in doing the work that you've been hearing about for the past 4 weeks. And I hope you find it as exciting and interesting as we do. Go to the judges' web pages at nycourts.gov, and you can learn about internships and clerkships. And I hope that you will think about that. With that, I turn it over to Dan, Judge Reed, and Ms.
Well, thanks so much. And thanks to everyone for joining us today. So it's my great privilege and honor to be doing this session with two really renowned and remarkable lawyers. So let me start with Justice Reed. Justice Reed is a graduate of Stanford University and Harvard Law School. He practiced as a lawyer for 23 years before he ascended to the bench in 2007. Before joining the bench, he handled cases in a bewildering array of areas and a lot of complex matters, from commercial disputes to employment discrimination, defamation actions, intellectual property cases, product liability claims, class actions, consumer protection claims, bankruptcy litigation. He also served and led the Civil Rights Bureau at the New York Attorney General's office. And since October of 2020, he's been assigned to New York's prestigious commercial division. And he recently presided over and dismissed a high-profile suit that President Trump brought against the New York Times and several of its reporters. And I am also joined by my partner, Loretta Lynch. And Loretta is one of those people who needs no introduction, but I'm going to give her one anyway. Loretta is one of the most gifted public speakers that you will ever encounter. She served as an assistant U.S. attorney in the Eastern District of New York. She did 2 different stints as the U.S. attorney in the Eastern District of New York, and she served as the Attorney General of the United States, and was the first African-American woman to serve in that position. And there she oversaw more than 100,000 employees, including the 93 U.S. attorneys. She oversaw the FBI, the Drug Enforcement Agency, and the Bureau of Alcohol, Tobacco, and Firearms, among others. And we at Paul Weiss have the great fortune of having her here. She returned to private practice in 2019. And since she's been back in private practice, she's led several of the most sensitive investigations, litigations, and regulatory enforcement matters for clients such as BlackRock, Syracuse University, and McDonald's. And I am Dan Toal, so I'm a litigation partner at Paul Weiss. I graduated from Dartmouth College and Georgetown Law School. I should have mentioned that Loretta is a double Harvard. She was Harvard undergrad and Harvard Law School. And actually, she and Justice Reed are friends from way back to law school. So after graduating from Georgetown, I clerked for 2 years, and then I started at Paul Weiss. And I've had the great fortune to work with some of the most talented trial lawyers of their generations. And I have now successfully tried 5 billion-dollar plus trials, and I've spent a lot of time not only on trial, but thinking about trials and reading about trials. And so what we're going to try to do today is cover the different components of the trial. So I should start off by saying that each of these components of the trial, opening arguments, closing arguments, direct examinations, and cross examinations, are probably deserving of their own 3-day session, but we're going to try and cover all of them in just an hour. So why don't we start off doing that? Loretta, maybe you could address your philosophy of trials and how you approach them.
Sure. Thanks so much, Dan. It's really a privilege to be here with Justice Reed and with you. And I would add that Dan is well on his way to becoming one of the lions of the trial bar as well. If you ever have a chance to watch him on trial, take it. I absolutely urge it. When you're thinking about a trial, I will tell you that for those of you who are young, either summers or young associates, for litigators, there's really nothing better than a trial. Our clients don't often feel that way because trials usually come about because negotiations have not prevailed, or there's been a real breakdown in a business relationship or some other structure between the parties. But for the litigator, there's nothing better than a trial. But it really is, there is an art to it, but there are some things that you can focus on that will give you the structure to help you move through it well for your clients, but also to develop your own sense of space in the courtroom, your own ownership over that courtroom, as well as frankly, be helpful to the trier of fact, because what you're really there for is to help the person who's making the ultimate decision. It may be a jury, it may be a judge. Your job is to help them see the case the way that you do so that they can come to a verdict that's consistent with your own argument. You are there to help people who know very little about this case learn about it in short order, decide what happened, why it's important, and come to a decision. And so when trial comes, it really is the culmination of everything you've been doing. The weeks, the months, look, we all know some cases prepare literally for years before they get ready to go to trial. All those things that have been going on, the depositions and discovery as you have fleshed out the factual record that you'll be relying upon as you build your case, all those pithy phrases that you've come up with that so aptly describe your case, why you have the right of it and why your opponent has the wrong of it. All of those are going to be completely filling your head. And your job is to distill all of this work into a coherent, concise, and clear presentation. And the first thing you've got to focus on is, what is the theme of your case? It's really what you've been working on all this while in preparation. What happened and why should you prevail? What happened? Why did it happen? And why should you prevail? Now, I added why did it happen because in most cases where there's any kind of commercial element, you don't necessarily have to prove motive, but you quite often do have to prove intent. The intent to strike a deal, the intent to walk away from a deal, the intent to consummate a deal or live up to a transaction, or the intent to live up to an obligation. And so you are going to have to get into motivation, even if it's not necessarily always an element of the case, but it's always key. And your job is to convince the trier of fact why all of this matters to them. If it's a jury, why should they care? Why should they care that two multi-billion-dollar companies are duking it out on the floor of the commercial division in front of Justice Reed? It's the fall of the year, Thanksgiving is coming, they're thinking about what to do. Why should this be important to them? Well, again, everything you've learned is going to tell you that. You're going to present this theme, you're going to present your narrative through your opening, through the witnesses that you call, the witnesses that you cross-examine, and the witnesses that you don't call in some instances. Now, some people call it like an elevator pitch, but you really should be able to distill the story, the theme of your case into a few sentences. Since we're focusing on the commercial division, for example, Is your client the company who entered a business transaction that would have benefited everyone and lived up to its word, but wound up with a business partner who decided to walk away from their obligations despite the clear language of the agreement? Is that who you represent? Or is your client the company who's the stalwart of the industry, who entered a business transaction in good faith, but learned of so many deficiencies which were never even acknowledged, much less rectified, that the deal crumbled before their eyes, leading them to exercise their clear rights to protect themselves, their investors, and the thousands of employees who depend upon them? So you see, the story of the case tells the trier of fact what you are going to be proving, what you are going to be showing as you go throughout your presentation. So know your story. You know it. You've worked on it for months, and weave it into your entire presentation. But the first thing to do is to distill it down into its essence. And think about it. Something happened here. Something went awry where you would not be in court. Why should they care? And why are you right?
And I think that's so important. And, you really need to develop the theme right from the outset of the case. And, your theme may evolve as you learn more about the case and you interview witnesses. But you have to know what your case is about. You have to develop the evidence to support that theme, and your entire trial presentation has to relate to and connect to and support that theme. Now, Justice Reed, you've been on this from both sides, so you've now presided over a lot of trials as a judge. What's your view of how most effectively to present a case at trial?
Well, I think you have to know exactly what it is that you are, as you say, trying to prove. I think one thing you can't do is be familiarizing yourself with the pattern jury instructions during trial. What you need to have done is, presumably before you drafted your pleadings, whether affirmative or responsive, you should have gone through and tried to figure out what your claims are and how you would have to prove each one of those claims. I think very often we are presented with a shotgun approach where people name every potential claim on the theory that, well, we'll throw it out there and maybe we'll find something eventually that works. And so we spend a lot of time in motions to dismiss and motions for summary judgment and discovery dealing with claims that don't matter, and where we're really winnowing the case down, getting rid of extraneous claims to now get to the point where we either have a contract claim, or we have an unjust enrichment claim, or we have a fraud claim. It's usually one of those three that ends up surviving. The other things have their place, but it may not be in your particular case. So you need to figure out the facts of your case so you know what your story is. As you begin to tell the story, you want to make sure that you do have that roadmap to where you eventually want to end up. And if you have that roadmap, now you can then go and work with your witnesses and your documents to see how they fit in the story. To the extent you're talking about a story theme, well, you have major characters in the story, you have minor characters in the story, there are little deviations in the story that help to bring to life the entirety of the story. And so you need to start figuring out, well, how does this document fit? What witness will be able to bring this document to life? And what do we have to ask that witness to do it? And then you want to make sure that you're only asking that witness to do what they can do, not doing anything more.
And I think one of the great challenges is, particularly for the types of cases that frequently come before the commercial division with hundreds of millions or billions of dollars in dispute. They're complex. We as lawyers have been living them day in and day out, sometimes for years before the case goes to trial. And I think that the real art of trying a case is distilling it to its essence. And that means a lot of difficult decisions about what to leave out, what ends up on the cutting room floor, so that you have a coherent and a persuasive narrative at the end.
Writers often talk about killing their darlings, where they have a phrase that they want to use, or some particular paragraph that they want to use, but then they realize it just doesn't fit, and it causes the story to stumble. And so you have to make the sacrifice and kill that darling for the good of the overall text.
So let's get into some of the elements of a trial. So talking to accomplished trial lawyers, there are frequently heated debates about what the most important part or phase of a trial is. So let's start off talking about opening and closing arguments. And Loretta, what's your view of what you're trying to accomplish in an opening and a closing? How do they differ from one another? And do you have a view on which of those is most important?
It's hard to say which is more important. I think they're equally important, but different. Your opening argument is really your first chance to tell that coherent narrative to the trier of fact. It's the first time, even with jury selection, but it's the first time they're really going to hear directly and steadily from you. And so it is one of your earliest opportunities to connect with them and to make them listen to you and to have them pick up on your resonance, your cadence, and your narrative. And you also are telling them what they're going to learn. Now, as you said so aptly, Dan, you've been working on this case for months, maybe even years. The jury's heard about it for a few days with jury selection. If the complaint is lengthy, they haven't even read it. Or they haven't been able to follow it, and it may be dense depending upon the facts. So they are hungry for someone to explain to them, what is this really all about? And that's when you present your theme. My client went into this deal, yes, with eyes open, but with every intention of living up to the arrangement. And we're going to show you how this other company completely walked away from their obligations with no regard for what they had agreed to do. And then you're going to tell them how they're going to learn all these things. You're going to mention the witnesses, but as both you and Justice Reed have noted, you can't overwhelm them. You're going to mention some of the witnesses. You're going to hear from the people who actually struck this deal and what they said and what they intended. Just by way, and you're going to say just a few of the people you're going to hear from, mention a few of them. Don't go down an exhaustive list. Mention some of the documents they're going to see. You're going to see some of the emails that we're going to use to show you that they never intended to carry out this transaction. And so what you want to do is tell them the story, give them some highlights of how they're going to learn it, and then tell them what it means. And that's how we're going to prove to you, or how we're going to show to you at the end of this trial that, again, whatever your main point is, that my client had every intention of doing the right thing by this, but was completely blindsided by the other side's failure to live up to their obligation. And you're going to have no choice but to find for my client in the amount of whatever it is. Juries are smart. One thing that I think many young lawyers often forget too is how difficult it is to just sit and listen. We're so wrapped up in the story. We know it. It's interesting to us. And maybe we have those great phrases that have survived Justice Reed's red pen, and they're still in our notes, and we're gonna toss them out for the jury. We might get that smile or that chuckle that says, "Oh yeah, they get it." But when people are just sitting and absorbing, there really is a physical limit on how much they can take in. They're sitting and they're listening. They're trying to decide what's important in what this person is telling me. What do I need to remember? And it's all new to them. So you want to make sure to keep your story and your narrative tight, Keep it concise, keep it short, and above all, respect their intelligence. So your opening is where you tell them what they're going to learn and the fact that it's going to support your position. And at the end of it, they're going to be compelled to essentially reward you with what you ask for. Your summation, the end of the trial, again, these same themes have to be kept up throughout. You're going to tell them, you're going to show them how you have in fact kept your word. Because the other important part about the opening is you want the jury and the trier of fact to trust you. One other point I like to make about openings as well is that with every case, there are going to be bad facts. There are going to be difficult witnesses on the other side. There are going to be issues that are in contention. Some people call it drawing the sting, but many trial lawyers effectively will talk about these challenges. They will say things, for example, now when my esteemed adversary has a chance to speak to you, he's going to tell you something different. He's going to argue that there's other documents that say something else. We're going to show you why that's not true, because you don't want the jury to be in the middle of trial, having begun to trust you, to learn about things that are detrimental to your case and think, hey, Ms. Lynch never told me that. Should I lean on her narrative so closely? You don't want to run away from the challenges of your case, because you are going to have a response for them, and you're going to tell the jury that as well. Now, in your summation, when you wrap it all up, you're going to go back over the trial. And again, the tendency can be sometimes to just list every witness and all the evidence that came in. I think as Justice Reed can share with us in the commercial division, sometimes you just have reams and reams of documents that come in. And to go through all of them in any argument would be not only mind-numbing, but would essentially send your jury running for the hills. But you again are going to keep up the narrative. Now, remember at the beginning of this trial, I told you it was about a company that tried its best to meet its obligations, but their partner failed to live up to their word. And they had no choice but to walk away. And you know who shared their how that happened? Witness so-and-so told you about how the deal was struck. And you want to pull a few key documents out to remind them that not only was there a witness, there are documents to back up that witness. And then you take them to the narrative again, and you remind them that there were witnesses to support it and that there are documents to support it. The biggest difference between opening and closing is your opening argument, you really can't argue, quite frankly. You can talk about what's going to happen. You can describe things. Your summation is where you tell the jury what it means. You heard from these three witnesses, all of whom said these varied things. Why is that important? Here's why it's important. Because it tells you that, in fact, there was no intent to deceive this person, or there was no intent not to live up to the obligation. In your summation, you can tell them what it means. That's why it's key, again, to tie everything to that theme. One of the things that can be really helpful in both opening and closings is the use of technology. You want to be able to put a few key exhibits up on a screen just to illustrate for the jury that not only do you have the goods to back up what you're saying, they will have an opportunity when they are back in deliberations to look at all the evidence as well and see, yes, in fact, everything Ms. Lynch told me was in these documents is in fact in these documents. But you also want to keep it again, geared to the relevant time period. People have a limited capacity of absorbing things. Take your breaks, present them with the ability to dig into the evidence themselves. And your closing is where you tell them what everything means. And again, you tell them what you want them to do. You're going to find from my client either no liability, or you're going to award my client a certain amount of money in damages.
So Justice Reed, in your perspective from the bench, do you have thoughts on the optimal length of an opening argument to make sure it's effective? And do you have thoughts about the importance of opening arguments in jury trials versus bench trials?
Well, just in terms of timing, I think, a lot of judges in the commercial division will set actually strict time limits, either 15 minutes or 30 minutes, or some people will actually put a chess clock on their bench to make sure that people understand that. I do think that the major point is to make sure that you are not taxing the jury or even taxing the finder of fact if it's a judge. There's a limit to how much you want to take in at the beginning. The purpose of the opening is to let people know what to expect, just to lay a brief roadmap for them to figure out what it is that's going to happen. If we go back to the story, to the story as theme, this is the introduction. You don't give away the ending in the introduction, but you do let people know what the story is about, why you should care about the main characters, and some sense of how they're going to go about this process. And so I think you want to always keep it as brief as you can to effectively accomplish that introduction, to lay that out there. And I think importantly, as Loretta has said, one of the things you're trying to do is connect with the jury, establish credibility with the jury, making sure you never overpromise about what to expect. And so I think that's the goal, is to lay out in as brief a manner as possible what they should be expecting, and to not stray from what you can prove. And as she said, if there's something negative, you want to at least lay the groundwork that it's going to be out there. Maybe you don't want to, you maybe want to just not introduce it right away, but at least explain how it's going to come about and give a bit of that, draw some of that sting away early on. In terms of summation, there, as she has said, I think you want to, you have an opportunity at that point to draw upon all the facts that have come out. Hopefully you have humanized particular witnesses so that you are able to refer to them by some name, and the jury will remember that this was that person and they held this position and it was their responsibility to make some particular decision. Hopefully you would have given them some time to work with some documents that are important. And at that point, if you want to flash up the document, or as Loretta is saying, have a visual display with your technology that has the document up on the screen in front of them, maybe on a big screen, or depending upon the courtroom, maybe individual screens in front of the jury. But to remind them of that. Also, in the one of the things that you want to do is again keep in mind that you are not taxing the jury. You're not going over everything that has been done, and hit those highlights that you talked about previously, and do some kind of flair to say that this document, remember, you can ask for this when you're back in the jury room. I'm not going to read it to you all here, but if there are parts of this that you want to read and look at it for yourself, please, I want you to look at this for yourself. So remember, ask for exhibit X, it is so-and-so, it's key information. Ask for it by name.
So, I'll say I don't often agree with Loretta. You want to try and avoid that whenever you can. I tend to think that the opening is the most important part of the trial, because, my experience is, particularly in this environment where people are getting information very quickly, people make up their minds very quickly. And, I view the opening as an opportunity, your first opportunity, your most effective opportunity to begin to persuade the fact finder. And if you can achieve that, if you can get them inclined in your direction, get them emotionally invested in your case, that becomes the prism through which they see the rest of the trial. The evidence that comes in begins to fit their structure and their inclination. And so, I think the opening, I would lean toward the group that says that's the most important part of the case. But let's talk a little bit about a process question for both Justice Reed and Loretta. What's your view on notes or a script, particularly in the opening argument? And, obviously for young lawyers in particular, there's a tendency to view the notes or a script as a safety blanket. What's your view on using that? And if that's not the ideal way to do it, how you can get away from reliance on a script?
Very, very good point. Very good point. Like, I think it's very natural to want to have that script. And in fact, because you are trying to distill so many issues into your basic theme, and you're trying to make sure you find and highlight your strongest points, it can be incredibly helpful to write your opening out all at once in one piece for you, and to practice giving that, whether it's before a mirror, you need to get in front of people. There are many people who use their long-suffering moms as the sounding boards for opening arguments. I had a number of colleagues in the U.S. Attorney's Office who did that. Many of us will drag colleagues into a conference room and give an opening. And when I've seen that, what has always happened is, once the person has read it through at least once, if you stand up in the middle of it, and I will literally take it away from a young lawyer, they immediately are better. They think that they're going to stumble, but you immediately are better. One of the things you have to think about when you are managing a trial like this is you have been living with this for months, if not years. You know this. You know what's important. You know what's key. So yes, it can be very helpful to start by writing out your opening, but then try and distill it down to just an outline or just bullet points. Some people just use note cards. Some people have one sheet with just the bullet points that they know they want to hit in front of them, just to look down and remind themselves, okay, let me make sure I cover this point. But particularly when you're opening, following up on what Dan said, and then Dan said an excellent point about having the jury see through the prism that you present. The jury needs to connect to you. You are having a conversation with people. You are telling them that you're going to present to them something that's very complicated, but that they can trust you to walk them through it and get through to the other side, and that they're going to understand it completely when you are done. They are going to trust you to do that. And to do that, you have to connect with people. You have to look at them when you talk with them. You have to look at a jury when you speak with a jury. Judges have different rules on whether counsel can move back and forth during counsel presentations and the like. And so you do want to know the rules of your courtroom. But some of the most effective openings I've seen have been where someone starts at one end of the jury box and has a conversation and slowly walks through to the other side of the jury box, so that everyone gets their full attention with what they're saying. And to do that, you can't be reading.
And so a lot of the very experienced trial lawyers I've worked with, even people who have been doing this at the highest levels for decades, will write out their opening longhand, every word they imagine themselves saying, and then they distill it from a 30-page outline to 10 pages to 5 pages to a single page of just headings. And, in my experience, I think that's the process that can help you get away from a very scripted approach. You're going to have these fantastic phrases that Justice Reed talked about in the version you write out longhand. It's really not essential to use those phrases. The important thing is to connect with the jury, connect with the fact finder. And one thing we frequently use these days, because people expect to be entertained, is we use PowerPoints to guide and structure the opening. So if you need a crutch, you've got a PowerPoint that you can use just to make sure you're going in a coherent progression through your opening. But the sooner you can get off script, just like actors, the better. So let's turn now to one of the other elements of the trial, which probably doesn't get as much love as many of the others, the direct examination. So Loretta, what are we trying to accomplish in a direct examination?
Well, now you're actually presenting to the jury what you said they were going to see in your opening through your direct examination witnesses. And as with everything, every moment in the courtroom starts with weeks of preparation in advance. You have met these witnesses, you've talked with them, you've deposed them, you've defended their depositions, you know what they are going to say. And I think Justice Reed said it best when he said, don't try and get everything out of every witness. Know who the relevant witnesses are, who has the key facts that you need to put before the jury in order to prevail, for your side to win, and who are the best people to share that knowledge and information with them. And it may not be that every person knows the entire story. So you want to think about who can best present the relevant parts the jury has to find in your favor. Sometimes you're fortunate and you do have a witness who covers the majority of the story. They were involved in so many transactions or so many decisions. That's great. One of the things that you're going to do also is, when you prepare your witnesses, figure out, how does this person communicate? Everyone's different. We've all seen witnesses, and we all have those friends who cannot tell a story in a straight line to save their lives. You do not want that person on the stand. If, however, that's the person you have to have on the stand, you have to have worked with them so that they know the key elements of what you need for them to focus on, and you know how to best direct them to tell the story. Direct examination. The lawyer who's now been taking previously, I should say, been taking center stage in opening, the lawyer recedes and the witness comes forth. The witness is now the star of the story. Direct examination, short, open-ended questions. A good way to think about it is one fact per question. What are you eliciting with this witness? And you want them to tell the narrative, because they represent your client to the jury. They humanize your client to the jury, which is very important, particularly in large commercial disputes, to make the jury connect with your client and your point of view. This may be a witness that you want to be able to just say, I'm going to direct your attention to this particular event. What was your position at this point in time? I was the VP in charge of whatever it was. Did you have occasion to work on this particular transaction? Yes. Tell us how that came about. And you need them to know that they need to start focusing on the things that are an issue. And at times you will say, with whom did you talk at the other company? What happened next? And then what did you do? Short, open-ended questions that guide them along a narrative. And for that to be successful, you have to know the narrative, and you have to know how they can best tell it for you. But in direct examination, the lawyer recedes and the witness takes center stage.
So I think that is a very important point, and it's difficult for a lot of lawyers who we all enjoy the sound of our own voices, and it's difficult for some of us to take a step back and let the witness be the star. But I still think the lawyer has an important role in guiding the witness through the story and making sure you're asking questions that elicit information in bite-sized chunks, because, as you said, it's very difficult for the jury to take in the information without cues about what they really need to focus on. What are the critical points? And so there's still an important role for the examining lawyer to play, even in the direct examination. Justice Reed, one of the innovations that is used sometimes in the commercial division, and I've seen it used in international arbitrations, is the written direct examination. So can you share with us, first of all, what the written direct examination is and your thoughts on whether it's useful, whether you prefer a witness on direct to testify?
All right, well, you have the written direct examination as it should be a time saving function. That's the innovation, is that rather than having someone sit on the stands kind of droning on for a long period of time, you could have them write out in affidavit form a short this is what we're trying to accomplish here. The downside to it, I mean, it saves time theoretically, but the downside is you don't get the ability to humanize that witness, to let them really warm up so that they are able to get to the important part, which we'll get to, which is the cross-examination. So you can have the direct by written direct, but if they are going to be crossed on that written direct, you want them not to be for the first time, put into the lion's den. You want to have warmed them up, to have gotten them used to being in the witness chair. Sitting in the witness chair is very intimidating for a lot of people. There'd be big time, CEOs, general counsel who get in the witness chair, and suddenly they're the center of attention, and they hadn't intended to be the center of attention, and suddenly they're very nervous. So part of the direct is getting them, a part of an effective direct is getting them comfortable, getting them telling a story from their standpoint, in their, in their territory. You don't want to throw them immediately into a cross. So I think it's, if it's only something that is mundane, it's useful there, the written direct, but it would seem to be that if it's something that was mundane and not really going to cause much in way of a cross, then you probably should be able to stipulate to that. I think it's important in your preparation to try to figure out ways to stipulate, to make sure you take advantage of notices to admit or requests for admission, so that you don't spend a lot of time in front of a jury or even on the bench just trying to lay the foundation for things.
Yeah, I think it's, it has its place with the written direct, and, arguably direct examinations tend to be somewhat scripted anyway. Before you present your witness on direct examination, you will have prepared them for the testimony, so they have a good idea of what questions are coming. You have a good idea of how they would propose to respond to those questions. But I still have a preference for examining the witness at the trial. I think it's an important way to humanize the witness and your client. And I think, obviously, if you're having a jury trial, written directs are not an option, but I think it's very important to be able to present your affirmative story through the witnesses that you're presenting on direct, even in a bench trial.
And it often ends up not saving time because people end up trying to add in things at the last minute. So they would have, everyone's preparing constantly in a trial. So it's going to be natural that in the last hour before the trial, you realize you wanted to ask this question and it's not in the direct. And so you try to do that. Now we have objections because we have a written direct, and the lawyer is doing more than just asking some casual warm-up question.
All right, so let's get to one of the areas of the trial that does get great fanfare. You know, we've all seen Perry Mason and movies where there's a withering cross-examination and the witness collapses and confesses. Loretta, in cross-examination, what's the goal in cross-examination? What thoughts do you have about the way to conduct one most effectively?
Sure. Cross-examination is for many people a highlight of a trial because it is the chance where, as opposed to directing your witness through an orderly direct, let me direct your attention to this, focus on that, tell us why you did that. On cross-examination, the lawyer is back in control, or you should be. Again, it all begins with preparation. You should be in preparation for trial, thinking through what the other side's witnesses will say and how you will counter what they will say. Your goal in cross-examination is to either neutralize a witness through bias or credibility issues, or to use something from their testimony to bolster your own case. Some people call this either a constructive cross-examination or a destructive cross-examination. And if the witness has clear issues of bias or credibility, they've been caught making multiple inconsistent statements before, you want to go right for those. You want to start with something, if you are fortunate enough to have it, something as strong as that. And it can often be something that you can piece together from the documents and say, well, Mr. Witness, you testified on direct that the reason why you thought that this was actually a good transaction to enter into was because of the value to the shareholders. And they said it on direct. Again, cross-examination, you are telling a story and you want the witness to answer hopefully just yes or no, because you are now back in control of the narrative. You can say, however, but looking back at this particular email, and you pull out a document that you found in discovery, isn't it true that 2 years ago, you said that the reason for the transaction was because you hated the CEO of that company and you wanted to do something different? You confront them with something. That's when you have evidence that you can use to attack someone's credibility. They've said something different before. You can show their bias. They have some sort of connection to someone, to a party, or a reason, a personal motivation to shade their testimony in some way. And if you have that, you want to use that. You mentioned that direct examination is scripted. Cross-examination should also be very tightly scripted. As I mentioned before, consider what can you get out of this witness. If you can't show bias or any problems with credibility, is there anything that they have to agree to that supports your narrative? And you want to go in with a almost surgical precision and say, good afternoon, Ms. Witness, you've been the VP of External Affairs for 10 years, is that correct? They have to say yes. And isn't it fair to say that it's very important that, and whatever your theme is, it's very important that any merger be looked at with this particular consideration? Why, yes, it is. So think about whether or not, are there things that this witness has to agree to that support your case? Because when you get back to the end of your trial, back to your closing argument, and again, there's very few things more powerful than being able to say, and I told you that this was going to be the case, and their own witnesses agreed with me. You want to be able to say that. It all comes from preparation and knowing what the witnesses will say. Now, sometimes witnesses will surprise you at trial with the way in which they express something, or there may be some nuance they've added to it. And there is the adage on cross-examination, never ask a question to which you don't know the answer. I tend to hold to that, unless, of course, the answer doesn't matter to you. That's very, very rare. But you want to ask on cross-examination, scripted, tight questions. The witness should answer yes or no, or should only explain a document that you give them that supports your position. And you are the one telling the narrative. Isn't it true that, in fact, what really happened was this? And here's a document that shows it. They may try and fight you. Well, I wouldn't say that. Well, look at the document. Isn't it dated May 10th? Yes. And didn't this all happen in May? Yes. So, in fact, what we're talking about actually occurred in the month of May, didn't it? Yes. And so the jury now sees the witness is trying to fight you, and you are just showing them what's already out there in evidence. And this is plain to everyone, and they have to agree to it. The challenge on cross-examination, in addition to not asking the question to which you don't know the answer, is going too far. You want to keep your narrative, and you want to have the witness use yes or no answers to your leading questions. A leading question, as we know, is one that is susceptible to a yes or no answer, but it contains the facts within the question. You know, isn't it true that this happened? Isn't it true that that happened? On cross-examination, you don't say, and therefore, isn't it true that in fact, you really wanted to kill this entire deal? Because that lets the witness explain something in a way that is never going to be helpful for you. You save that for your closing argument. You get the witness to establish the facts you need, and you tell the jury what it all means later on.
And many advocates compare cross-examination to an argument, that you're actually making statements and trying to get the witness to agree with the statements you're making. But in the process of making these statements, you're laying out your argument for the fact finder. And ideally, you've got the witness locked in so they really can't fight with you. Justice Reed, do you have thoughts on the optimal length of a cross-examination? I've seen cross-examinations of witnesses that have gone on for multiple days. I've seen incredibly effective examinations that have been conducted in 5 minutes.
Well, I think it should be short. I think it should be short. I think it should be surgical, just as Loretta said. I think it should be civil. I think you don't want to bludgeon the witness, because I think you want to have, again, this perception in front of the jury that you are the one who is fair, and they can always depend on you to be fair. That doesn't mean that you should be, sugarcoating things for the other side. I think you just want to be, as Loretta is saying, you want to be surgical and ask the short one fact question, so the witness has to say yes or has to say no. And if they don't say the right, if they don't say the right thing, then you follow up with a few things that are also very short to try to get them locked in. But you don't try to convince them. You don't want to get them. You're not going to get the Perry Mason. I did it. You just want to get the person to answer your question, yes or no, and then move on. And you are saving, the zinger, you are saving for closing argument. And I think the problem with having the long cross is that you allow that witness. You don't want the witness, if the witness is the story, if you want the witness to be the story on direct, you don't want the witness to be the story on cross. The longer you have them there, assuming they're a wily witness, at some point, then the jury will say, "Oh, that woman is kind of crafty. I like the way she handled that lawyer who was trying to trick her." You don't want that. You just want to have short yes, no, and then reserve for closing. Well, the witness said this, or the witness said no, even when I showed the witness this document. You can look at this document, and you look at this document and you tell me, you look at this document and you you talk about this with the other jurors. Which one do you think is, who's telling the truth?
And Justice, as a judge, there are different judicial philosophies. So sometimes in cross-examination, you have witnesses who are fighting you. They're evasive. They won't answer the question. If you ask them to give a yes or no answer, they give long narratives. What's your view on the appropriate role of the judge in an examination like that? Do you try and help the examining lawyer out? Do you let them fend for themselves?
Well, it depends on it depends on how the lawyer is asking the question. Very often the case, it is very often the case that the witness simply has been prepared well, and they know that the question is not a yes or no question, or it's a multi-part question, And so, I can't help you if you've not asking leading questions. So if you ask a leading one fact question, then I'll be happy to say, well, that's a yes or no question. You didn't answer it. So we don't need all of this. It makes a little, there's a little difference between whether it's a jury or a judge. If it's a bench trial, it may not bother me as much, but one of the things that I think every judge is doing when they have a jury trial is trying to protect the jury and trying to protect the record. So you don't want to have someone spouting off an answer that's not responsive to the question. And so then what happens is the balance to try to be firm with the witness while not trying to influence the jury by having them think that you are angry at the witness.
And Loretta, let me ask you about the difference between cross-examining fact witnesses on one hand and expert witnesses on the other hand. What sorts of consideration should people have depending on the different context there?
Sure. Look, you're going to see a lot of expert witnesses, particularly in the commercial division, because they're going to be sometimes some fairly complicated economic issues or even just basic issues of things that you might view as basic, but valuation can also be complicated, and you can have experts there. Typically an expert is paid. Everyone knows that nowadays. And so people always say, well, you want to bring out that they were paid, that everyone kind of gets that. But you really want to focus on with an expert is, are they really helpful? An expert witness is there because something might be just above the average knowledge of the jurors as a group. And it's all there to help them understand something. So what do they rely on in crafting their opinion? With whom did they talk? Who did the actual work in putting together this opinion? I mean, is this really your expert analysis, or are you just someone who comes in, looks at papers and churns out whatever the other side wants to say? And so you're not really going to, they're not really going to have a bias per se. I don't really think, being paid by one side or the other is frankly, for an expert, that much of a bias issue. But they are going to have some substantive things that you can cross them on that go to the heart of whether or not they really are helpful. Number one, are they an expert? You might want to cross on that, but also just in terms of how did they come to their conclusion? Did they look at any of the relevant documents in the case? In their field, do they interact with people who do the jobs that have been discussed in this case? And you can actually attack an expert very well by saying that, look, they're perfectly nice, they're perfectly professional. They just don't have the expertise in this area, or they haven't talked with anybody who knows about this particular issue. And while it was great for the other side to bring them in, you don't need them. You don't need them. Your own common sense will tell you, and you bring it back to the jury in that way. And so that's what I find, in my view, is more effective than trying to, again, attack an expert. It's not the kind of witness that you're going to get into an argument with or have raised voices with, because they're going to present as very professorial and as almost a neutral person coming in to share things. And you want to show that, you don't really have a basis for the conclusion that you have drawn.
And I think particularly with experts, there are lots of occasions where even the other side's expert will acknowledge points that are favorable to your case. So I think you want to look for opportunities to help make your case through the other side's witness. The last thing I would say about cross-examination is that, generally you want to grab the jury's attention. So it's nice if you can start on a particularly consequential point and a high point, and the examination on a high point. You don't want to peter out during the examination.
Absolutely.
So with that, I think we have raced through the elements of a trial and done as much as we can to cover them in an hour. So I want to thank my panelists. I want to thank everyone who's been watching this for their attention, and I encourage you to try and get as many trial opportunities as you can. It is increasingly challenging, I think, to get the opportunities to go to trial, and it's well worth it if you can do it.
Thank you so much. Mr. Toal, Ms. Lynch, Judge Reed, thank you so much. You got me thinking about some of my procedures. I'm gonna rethink that 15-minute limit. And I want to also thank the advisory council and also Kelly Dry and all the folks here at the courthouse that helped us put this presentation together, the 4 presentations. And again, I hope you'll visit our website and think about clerkships and internships. So thank you. Thanks, everyone. Have a nice day.
Thanks so much.
Sure.
Take care.